Fox, I see you got here first. Okay, J Fox, what's good? Gangstar. Sham Kiona, what's good? 123 first. Whiskey 704, what's good? KT, what's going on? How are you guys? Yo, can you believe the summer? Pineapples, what's good? Pineapples, how are you? Pineapples is in the house. What's going on, guys? Bon, I see you. 313 GG, I see you. What's going on? Scorpio, CA 1983. Is it so for real and true? So for real and true. Petty Patty. Hey, boo. Sweet Shy, Retro, my fro. What's going on, everybody? Fiance, what's up? Guys, welcome back to Real Talk Bougie. We are going to get into another live reaction. This was good today. I was trying to watch it, y'all. Sis, ooh, just been going through it for about a couple of weeks now, but I'm getting better. I'm like in the 90 percentile of what's supposed to be quote unquote normal. I'm getting there. Okay. Oh, you too. I love me some you. Thank you. Happy Friday, everybody. We made it to another one. I promise. I am going to be working up here on this internet, but I have to get caught up because there's so much to do. There's so much to talk about. I talked through the whole entire song today. Can you believe it? Was that bad of me? Welcome, everyone. Welcome to Real Talk Bougie, guys. We are going to talk the Sarah Boone hearing today. It's so interesting. Sis is pro se, which means she's representing herself. This is not just like a car accident. It's not a pro se divorce. It's not small claims court. Sis has been accused with second-degree murder, and she doesn't have a lawyer. She does not. She's had 8 lawyers, and she has been a menace to the Florida Public Defender's Office. And the judge is like, ma'am, we're tired of you. We're tired. It's been 5 years. We want to take this to court. We're not with the shenanigans and the foolishness. And by hook or by crook, this trial is moving forward. And you're not stopping no shows anymore. So if you want to keep playing, I'm going to show you what keep playing is going to do. And what it did is that basically a couple of weeks ago, Sis got chanced out on a lawyer. Basically, they're not so Sarah is very much like a little bit of a victim over here. And either she doesn't want to comprehend or she is using this as a tactic because she's, I don't know. You could take a couple of different ways, but she talks about fair, not fair, all of these things. I'm being denied. She's really not being denied an attorney. She's just not getting one paid for by the state of Florida. Florida has said basically we're not paying for that anymore. You can get your own or you can represent yourself. You have 2 options. Represent yourself or pay for it yourself. We're not paying. That's what it really is. I wish the judge would say that because I think she would be able to comprehend. That would get a little bit more through her skull because she doesn't want to understand. She's being quite difficult. Hold on a second. I didn't do something because I was trying to experiment. Okay. My bad. Are we okay? I think we're live on everything now. Okay. All right. Okay. So welcome to everyone. Make sure you follow this channel. Make sure that you subscribe, all of the things. Anyway, she doesn't want to understand. She does not want to understand, and she's not going to understand. Anyway, let's get into it because I felt like it was a really good hearing. And it was very kind of like insightful in the sense that if you're following these court cases, I mean, this is really what can happen if you play around too much and you don't have money and you're relying on the public defender system. I think that people are, if you're unable to be represented and they feel like you're taking too much advantage of the system, and you're really in theory using the system to prolong your case, which is what the judge, it's been alleged that's what the judge is trying to either avoid or stop. um this is what can happen. Anyway, this is what happened today. So sis filed a couple of motions. These are the motions. Sarah Boone is very much into writing lots of jailhouse correspondence. So she sent a 10-page document, and it was a motion to lawfully receive. You're going to hear about this in the hearing today. It's a motion. Let me make it big so you guys can see it better. It's a motion to lawfully receive, review, utilize the original hard copy. Make sure the gates are closed, please. Hard copy discovery, 2 boxes A and B, submitted to the court by former attorney on June 28th, 2024 for preparation for the trial. So she wants her hard copies. She's been asking for this, which I think that got denied, but we'll see. Also, she wants to be able to be handcuff free. She wants to not be in shackles, and she wants to be able to navigate the courtroom. So those are two of the main things. I'm not sure if there was anything else. Signature of the attorney party. She had some other motions the other day, and she won a couple of her motions. So let's just see. I haven't read this whole thing. This just got published. But they're going to go through some of this in this hearing, and one of her motions was approved. So let's see. She's walking into the court now. She does not have shackles on her feet, but she does have I think she has chains around her waist, and her handcuffs are secured to her hands. One of her motions, because she is defending herself, she is going to have to take notes. And this is the jury box. She was able to get some wins today. So let's just go through them. Let me see if I make this just a little. I think I've already got on like 1.1. I don't know what 1.2 is going to do. But let me just see. Let's try 1.1.
Madam Clerk.
Quite sort of pissed.
Steve Ketcher on behalf of the state. William J. for the state. Ma'am, good morning. Can you raise your right hand? Madam Clerk will swear you in.
You swear or affirm the testimony you give shall be the truth.
All right, ma'am, good morning, rather. Could you state your full name and date of birth for the record for me? Okay, we had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mail.
So he's going to ask her a bunch of questions about how she received her mail. Did she receive her mail? Because she was complaining that she did not receive her mail in a timely manner or hadn't received it. So I think there was a difference between like jail mail and legal mail. So I guess legal mail may come straight to the jail, and regular jail mail goes through some sort of source where they kind of go through it. I don't know what they do with it. I'm gonna be honest. I can't even begin to tell you what the process is that is different. But legal mail comes straight to the jail, and it gets there much quicker. And it really is for purposes of you to be able to correspond with your attorney and, regarding your case or your legal matters more quickly than just kind of like, hey, babe, here's some pictures, things of that nature. So they had to clear that because obviously also she's now her own lawyer. She is Sarah Esquire. So they need to use legal mail so that she can get things quickly.
And I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing, and
he's also going to kind of go through, if you're listening to these dates, he's basically going through the dates very quickly where she got warned, she was told, she was asked, she was warned again. Like, this is your last opportunity. Are you sure this is what you want? When he tried to kind of mediate a little bit, not mediate, I'm just using that word, but he wasn't trying to mediate, but he was trying to kind of remedy the situation, let's say like that. She doubled down with a whole long 15-page letter about all of these things. And he basically was like, you know what? I'm going to give you what you want. Because it seems like to him, what she wanted was to represent herself. And she was already threatened that if she lost another attorney, that they may not replace that one. Okay.
order was entered and a notice of hearing was set. That order was hand delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motions seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of Detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B, P.O. Box 4970, I apologize, P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th?
Correct.
Okay. The next was a notice of delivery of digital copies.
The whole time
that was e-filed by your.
The whole time I was in Orlando, I couldn't not think like, oh my God, Sarah Boone, this whole thing. And I'm not going to lie, I was tempted to go kind of do a drive-by just to kind of, but I didn't have time. I really didn't. We were like, if we hadn't gotten sick, it would have been a completely different story. But I think she lived in Winter Park, which we were over there. Any of you guys in Orlando or know the Orlando area, we were right over there at the Marriott Grand Vista Resort, which is on I Drive. And it's literally like a mile down the road from Benihana's, David, something. I forget what the other, like a Florida Central. We were 2 blocks up from Aquatica, and we were 1 block from SeaWorld. So you come out of our resort and you make a right, and the next light is SeaWorld. You go up another light and we're at Aquatica. So that's like one of our favorite spots. So I was tempted, but we didn't. The only place that we really ventured out to outside of like our general vicinity was when we went out to my cousin's house.
Your former attorney, Patricia Cashman, on August 1, 2024.
But I was tempted. I was very much tempted to go for a little like, oh my
Chelsea
God,
Copsell
this is the
and Scott
scene.
Lowen, taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address.
I wonder, she's having trouble with, you're going to hear this in the video. I don't want to stop too much because it's going to take us forever to get through this, but She has all of her discovery now, and I'm sure her discovery includes the body worn cameras, the interviews, and her cell phone her cell phone camera footage of George. This is her own little personal hell she's going to have to go through. When they play that in court, maybe it's going to be a problem.
Addressing PO Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was sent that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so.
Okay.
For receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the PO Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about.
I don't know what you're talking about.
That was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail.
Judge Kranik is not playing with her at all.
We have this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Boone Lane, Chief Investigator, owner of Prison Break Investigations.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane a copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good. Debbie Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request.
Ooh, nosy. Yes. Well, it won't matter. She's not getting any kind of a gag order or anything like that. Florida, I think there's no way that they would now, if there were some other reason to take a look, we live in a world today, if it's not videoed, it didn't happen, right? There is no way, there's absolutely no way that they would not have a camera going when she really seems, she's going to probably say, we could probably track through this proceeding how many times she's going to say that something's not fair or she feels like something is happening against her will, all of these things. And it's kind of like, well, what about the fairness to George Torres? Like all of those things. So there's no way that they're going to turn off a camera or not have cameras or the media available. We will all be there. We'll be there right there with you.
To seal is
She definitely won't be getting what she wants.
On the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses of trial. I don't have.
Yes, thank you, Patty Patty.
It wouldn't be in order. It would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone.
Yes, they're broken down by folders.
And the folders, or the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender I can send it to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Cacciatore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specific.
Okay, so for those of you guys who don't know, so her discovery, she complained. First of all, she complained because of her storage space at the jail. and said she didn't have a private place to store her boxes, her evidentiary, her discovery, right? Which is all of the materials that she'll have to do her defense. So everything that her lawyer had in banker boxes that she was either using to present or just to use as fact finding, all of the depositions, all the information is in these two boxes, right? She says she doesn't have a secure place to keep them and the jail didn't want to take ownership of it. So there was a private investigator that her lawyer was using to who she'd hired to help with the case, and the private investigator took custody of the two boxes and digitized everything. So all papers were scanned in, anything that was, maybe anything not paper was photographed to the best of their ability to be able to give her at least visibility, all of the things, right? And everything was put onto a thumb drive so that she can review, read all of the things, right? And she has access to a laptop from 8 to 4 and legal pads and pens, things of that nature. And she can use the laptop in her dormitory from 8 to 4. I don't know if she has internet access or not. That might come up. She asked about it last time. And she can take her notes and all of the things. She still wants physical copies, and the judge was like, "You told me you didn't have room." Hi, Bible lady. Hey, everyone coming in. Do me a favor, hit the thumbs up for me. Let's keep going. We just pretty much got started. We're just now getting into it. Everyone's sworn in. The judge is asking some questions, but this is actually a pretty good hearing. Let's go.
Specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format. So I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them. And then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the
to,
most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
Okay. All right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio only files.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure, okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her? If you know?
I am.
Okay, all right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents.
I'm not sure if they have actual cells. She says she's in like a 60-person woman's dorm, or maybe there are individual, like, partition rooms, I would imagine, but I don't know for sure. How soon do you guys think Mr. Lane is going to go see Sarah, and he's going to tender his resignation as a private investigator, or is he going to go ahead and just get that budget money, because there is money already allocated to him? You think he's going to be smart about it, or he's going to get all, I don't know. Hopefully he can he can stay with it, because I think he knows that the people are depending on him to not let her get up under his skin, so we can get this trial popping, because it's been 5 years in the county waiting for justice for the family, and for George Torres, who who she manipulated his death, okay, however it really should be said. But sis is accused of second-degree murder.
Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department, so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, Hall, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow.
My bad, guys. I was chewing on ice. I didn't realize I wasn't on mute. She is representing herself. She's gone through 8 public defenders. I think she's had 9 lawyers altogether. It's either 8 or 9. It's either 7 or 8 public defenders, 1 paid attorney. And the last public defender, they'd warned her maybe on public defender 6 that she was basically wearing out her chances with Florida, and that that she really needed to make this work, because every time there's a new lawyer, guess what? There's going to be a little bit of a delay, because in all fairness, every lawyer has to get up to speed with the case, file their motions, do all of the things, prepare accordingly, make room. And it's really, the feedback has been that Sarah needs a very specific amount of attention that really requires almost her being someone's only client. And not to say that that's what it has to be, but that's just what it appears to be. And she's chanced out with Florida public defenders, and basically they've told her she can pay for her own lawyer or she can represent herself. She doesn't have any money, so this is what she's having to do. We are sick of her here in Florida. Absolutely. Okay.
Meet Ms. Boone
The
at
good
approximately 9
taxpayers of
a.m.
this state
You
of
will meet
Florida, the
Mr.
beautiful state
Muhammad
of Florida that I
as
love so
well.
much.
Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You have the smaller one, which was everything you digitized from the 2 boxes, and then you have the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes, Florida is
Yes.
playing
Okay.
for
If you wanna, can he
jailbreak
be released?
jailbreak investigative
I
services.
guess I'll see you at 9.
Okay. Sir, if you could endeavor
Oh
to do
my
that today,
God.
I'd
I would
greatly
be
appreciate
like,
that. All right, thank you very
lady,
much, sir.
don't bother
Thank
me,
you.
or else you're going to be out of a private investigator and you're not going to be able to
All right, the
find
next-
one.
Matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function.
Whenever I hear the word shackles, I wanted to say shouts out to Jasmine on Facebook. And we have a couple of folks joining us on Instagram. So welcome, 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 whoever's passing through. Let's keep going. Ooh. So yeah, so she filed this motion right here, guys. Hold on, let me share my screen over on this one. So she filed this motion basically regarding being able to not have her shackles and handcuffs on while in the court during hearings, so she can adequately take notes, because it's very uncomfortable for her with her handcuffs to be able to take notes. Period. So she would like to not have her shackles. So it's kind of funny because one of the deputies comes up, they did some due diligence and they found that she had been difficult a few times. And I think that if Sarah would get about her feelings and listen to the direction of the judge, she could understand a little better how and what to do. But let's listen, because it's very interesting. because she goes automatically into complainer mode. She goes into it's not fair mode. She goes into, I don't know what to say. I'm doing this for myself for the first time, Judge. She goes into that whole thing. And that's not really helpful because he can't help her the way she wants him to because he's not giving legal, he can't give her legal advice, right? So, but she manages to get her point across, which I was kind of like, this is going to be an exercise in her on this is what you need to expect when you get to, like, you need to stop being such a whiner. You need to stop being a pissy little whiner because sis, you going to jail one way or the other. I mean, I'm just calling it. She does have her right to due process and she is going to have her trial and all of the things. My opinion is just that there's just so much overwhelming evidence against her. It's just a matter of how long, not if. So, or it's like when, right? Okay, let's see what you guys are saying. Are your tax money is being wasted? Ma'am, you have all your evidence. Just throw a plea out there so you can agree. Enough is enough. You know what I'm saying? Like, ma'am, we saw the whole thing. Can you just does she doesn't she's not gonna plead guilty. She will not plead guilty. I don't think her ego will allow her to say she's guilty of anything. Isn't that a shame? They should only be allowed to have a maximum of 3 public defenders. You know, I think that this has set a precedence, and I think that this judge really artfully kind of when he did the 16-page motion, he really laid out like, okay, this was number 1. Okay, that's not your fault. Number 2 happened. Okay. Number 3, and then she started running people off. And then, you know, some people didn't even throw her under the bus to say it was her. They just said, I have a conflict, this, that, and the third. But at the end of the day, it's been 8. It's either 8 public defenders or 8 in total attorneys, including, like, let's say public, 7 public, 1 paid, because she had 1 paid at first. But at the end of the day, the bottom line is she's gone through a lot, and they feel like these maneuverings have cost obviously a lot of time and money and delays, and also has delayed justice to the family and to the victim. And it's like, enough is enough. This has been 5 years. Let's get this going. And you have basically chanced yourself out. They have a very well documented paper trail of warning her. I don't think that she got it. The last warning, I don't think she understood the last warning. And basically, they were trying to see if she would work with the last lawyer. And she sent a damn, I don't even know how long the letter was, but it was long as I don't know what. And basically, he was like, okay, like, based on what you're saying, this is what I believe you want. Right. So that's that.
Equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay. So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions. We'll cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay. All right. Let's go ahead and call your witness.
Thank you, Pen Pal, for supporting. She's like, is that today? Are we going to do that today? No, we're going to take you back to the county jail, waste more time and money with the sheriff, and bring you back. What, like, you know what I'm saying? Like, girl, ain't nobody got time for all that. You're here now. We got the shit, you know, like, sis, wake up. Your trial is happening. Sis, this is actually, she might need some damn Disney magic over there. Sis is like, ma'am, hello, your trial is getting ready to happen. Wake up. It's time. It's time. It's happening. Wake up, get some coffee, eat some breakfast before you come because baby, it's happening. You are officially in trial mode. Okay, it's happening, sis. It's not trial right now. It's pre-trial, but trial is happening. It's commencing. It's getting ready to start. Okay, what they're getting ready to talk about right now is her first motion, and they're swearing in one of the sheriffs who is responsible for court security. And basically, this particular officer is going to give his opinion on whether it's a good idea for Sarah to be able to navigate, operate freely in the courtroom based on her history, what they know, the charges, and all of the things. So let's get into it.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin.
And this happened this
Thank you.
morning,
State your name,
8:45.
proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you worked that assignment?
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me, it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Loden?
I do.
Go ahead.
First off, in your in-quotes research that you've done on me, the domestic violence case
Here we go.
that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask 1 fact per question.
I am prepared to give her the date.
Hey, Danny. Hey, everyone coming in.
September
Welcome,
15,
welcome, welcome.
2023. That was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At the
court?
jail, yes.
Who is your contact, please? I've never missed a date.
This is a database that I got this information from.
Do you know when it was last updated?
It's 5/9.
Okay, so do you know how, I have never missed a court date to the present date. I don't know specifically what these 3 dates are for, in order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
Sarah better chill, like take it down a notch. And remember, Sarah, you're not sitting there as you, sis. You're sitting there as your lawyer. You're Sarah the lawyer right now. You're not Sarah the accused of second-degree murder, even though, yes, you are, but you're not. So you got to chill. And when you go to the jail and you want to start asking people a bunch of questions, you better do it as Sarah the lawyer, because if you start acting weird, that's not going to go well for you. Like right now, she's actually winning some of her motions. Things are kind of going her way. The judge, I don't want to even say he's appeasing her, because he's very much kind of by the book and he's not playing with her, but she has been advancing the needle with some of the things that she's been asking for. And I think if she gets all Karen weird, it's going to be a problem. So she might want to choose her battles wisely, because it's not going to go well for her.
For the September 15, 2023, it is Corrections Officer Portia Hines,
Could you
Not
spell her last name,
Portia.
please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
Okay, I'm gonna just first let me tell you guys. So Kiva, welcome, 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 boo. We did set up a playlist. So I've got a playlist for Sarah Boone. Sarah Boone is known as the suitcase, it's like the suitcase murder of George Torres. It's her boyfriend. So all of the details I'm gonna have to kind of defer so we can keep going, because it's like an hour-long video, but we're a good ways in, but we've got like about 35 minutes to go. Basically, she is in Orange County, Florida, accused of second-degree murder of her boyfriend George Torres. And sis is it's bad. So she has been prolonging out. She got arrested right at the beginning of COVID. So there were all of kind of like the COVID delays and the backups and all of that stuff. And in that process, she's gone through a host of lawyers. And because of that, she's chanced out with the state of Florida. So she is now what they call pro se. She has to defend herself. But it's really super interesting. Go to the playlist and get into it. I'm sure you're gonna really enjoy it. But this is like a really good hearing. So let's get back into it. And I think probably like maybe 2 videos ago, I kind of went to the beginning of Sarah Boone. So and the playlist isn't very long yet, because the trial is getting ready to start in like 2 months. So this is a good time. This is all pre-trial. She just got notification that she's going to have to be pro se. She just lost her last lawyer, and Florida said no more. And now they are into pretrial, and she is having to do all of the heavy lift, all of the work herself. So hopefully that helps. But yeah, Sarah Boone, Orange County, Florida. And I've got some documents and stuff like that posted in my Patreon. So join my Patreon. There are some free member posts in there with the Sarah Boone documents and things like that. So if you want to read some more about what she's got going on, her letters, things of that nature, some of that stuff is in there.
To attend court. It doesn't say specifically what your hearings.
Okay,
Second one, it'll be Officer.
You think so
Christy
too?
Green.
Always a lady.
what is
She
the
might
state
try to
for that?
escape. Well,
Sorry, is that-
which
they're going
date
to
is
talk
it
about that in a
you're referencing?
minute.
That's gonna be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K,
Greene,
yes,
10/16/23.
yes.
Okay,
And the third one is January 28, 2021. And the officer is Jasmine Scribner, Scribner.
what are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center, transport officer was notified. All proper notations were made in the IMS.
Okay. And January 28th?
Approximately 0334 hours, inmate Boone Sarah was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of, that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information out.
Okay, so I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
Rather than say, Judge, I'd like to have the corporal or whatever his name is, sergeant, get more information to substantiate these allegations before you rule on me not being able to have my restraints, just to be able to, just because maybe I could have said one day I didn't want to go to court doesn't mean I didn't go to court. So that doesn't really mean that I'm not going to be cooperative. Like, there's a way, rather than sitting there and taking it personally, she keeps interjecting like, well, I never missed court and da 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 da. Well, they documented that you did, sis. And the only other way to know if you missed court or not was to go look in the record, which you should have access to now, and see, were you present, because they do take copious notes. Do I have it pulled up? Look, let me show you guys this. This is today. Okay. They already have the notes filed for today. You see that? 8/9. They already have today's notes posted. And look what it said. Corporal Gavin. Okay, that's who we're watching right now. They have the status hearing for the 14th. They go through everything that happened today. Hold on a second. All of the notes are here for what happened today. The court went through the mailings of the documents with the defendant. The defendant advised the court that she's received everything the court has mentioned. I mean, they have the document that she just sent to the court, that she gave to the court on Monday, the 10-page document that I showed you guys earlier. Like, they put everything in here, which is amazing. I love it. She's tripping. all she'd have to do is actually log in. If she was in court, they're going to say defendant was present. So it's very easy to fact check this instead of sitting there and getting all pissy and acting all Karenish and turning people off and being exactly who people are. You know what I mean? Like whatever, she can do what she wants. But at the end of the day, this is going to be a complete shit show. Like I predict in like about 2 more hearings, she's gonna lose it. Hi, Ann Harmon.
I'm going to sustain the objection.
Hi, Mimi. What's going on? Hey, everyone. Welcome, welcome, welcome.
So the domestic violence, the original was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, so it's a statement.
Sustained.
Forgive me because I don't know what I'm doing.
Sarah, how hard is it for you to understand that you are, as the defendant and defending yourself, you're defending yourself as Sarah Esquire? So you have got to stop. I didn't do this. I didn't do that. You have to put on your best lawyer voice, sis. You're gonna have to stop. And I guess it's a headspace. It's a mind shift. And she is, girl, she's fugazi, but it's like, my God, would you just get it together and stop? Like she's such a big baby. The trial has not started. We're still in pretrial right now. So these are the pretrial hearings, and they're setting the pace. She basically was notified like about a week and a half ago that she was notified maybe 2-3 weeks ago that she was going to be pro se. And these are the hearings leading up to, these are the pretrial hearings leading up to trial, which is set to start. Hold on, let me look. Her trial is set to start. Trial is set to start on, it might be 9/26 or 10/7. 9/26 might be like, okay, so 10/7. Trial management conference is happening on 9/26 and trial starts on 10/7. So this is all pre-trial. She's just gotten all of her discovery, all of the things. So we're in pre-trial. So she's questioning. This is the head of security for the courthouse. He's the sheriff that handles security, and she wants to not have her shackles during court. So they're trying to work out those logistics at this moment.
I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you.
Yes,
what to
she's
do.
representing
I cannot
herself,
provide you
Mimi.
any legal
That's
advice.
pro se.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that isn't your history.
Okay, let me interrupt right here. So so the corporal is sitting there telling her, okay, so you had 3 situations at the jail and you had a domestic battery situation that happened with George Torres. George Torres coincidentally happens to be the reason why you are sitting in this box right now for on second degree murder. Like, sis, really? It's like I'm wondering, ma'am, are you actually thinking of why you're sitting there? Um, you may not have been charged at that point with domestic violence, but sis, fast forward, you're being charged with second degree murder of that exact same person. I think it's the exact same person, right? I believe it was that same person. Um, yes, it was George. It was actually George Torres. So, um, can you believe her? She is an absolute like, ma'am.
I
It's a
understand, but I
mess.
was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
I'd
It
be
is
like,
not on my
okay, you
record.
weren't charged with it, but you're sitting here now
The
for
rest
second
is on
degree
the
murder.
But the charge for the domestic violence is not on my record.
No, you were never
Just
convicted.
to ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that two of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement, question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made,
What's that?
the decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Ooh.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask and answer.
Sustained.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Girl, you better not waste your time on, first of all, spoiler alert, she's going to be able to not have the handcuffs on. But at the end of the day, she's so worried about these minor things. Ma'am, you are on trial for second degree murder and you're worried about whether you have handcuffs on, and you seem to be taking notes just fine. You need to be worried about whether you're going to spend the rest of your life in jail, in prison, rather than arguing back and forth with the corporal who is looking at your overall history and your track record, not necessarily your convictions. They're making a security decision and she's being triggered.
Am I, in your opinion, a flight risk or
Girl, you don't have any
detrimental
money
to
and
the
resources.
courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you to not be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Right.
And it is now 2024. Okay. And you're going solely off of what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped, that I would not be able to be unrestrained?
Correct, your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on it.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
They're asking for his opinion. They're asking for his recommendation. They're asking, as the head of security, as the person that keeps this building on lock and keeps our workers, our judicial officials, our lawyers, our visitors, the public, everyone safe based on what they are reading about you and what we know about you. What is the recommendation? And I think most of the time with law enforcement, we'd rather be safe than sorry, especially considering that she's very much of like a simmering pot. And you really don't know what she would do. I mean, we don't know what she would do. We know that we've seen that video. Anyone who's kind of new to this case, just go to the playlist to the very beginning. We know what you would do. You actually sat and watched a man suffocate. So we've seen what you can do, and they're not sure. And because maybe you're not necessarily violent, they just want to be sure that they're not sorry versus being safe. So the best thing to do is to keep the entire courtroom safe and not have to go running around looking for you because you try to go to the bathroom for too long, or you try to take too much liberties and think that you're free when you're not.
But it was never proven, correct? Because it was dropped?
It doesn't have to be proven.
It didn't happen.
Okay.
Exactly. She's saying, well, I wasn't convicted. And he said, well, it doesn't mean it didn't happen. Just because you weren't convicted and just because it didn't go to court doesn't mean it didn't happen. Basically, they're just looking at the overall track record. It's not convictions. They've asked me my opinion, and my opinion is no.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
Oh,
Right. Spoiler alert, they do remove the cuff. She will have some sort of like a party to like a shock collar, or a shock cuff on her leg. So basically like the same thing, any of you guys who are familiar with shock collars, it's going to be like an electric volt that if she tries to get cute, then it's going to be like a stun gun and it'll stop her in her tracks. So that was basically, and the funny thing is, you'll see this in a minute. She was basically already getting it and she's continuing the argument. The judge had already said she didn't have to have her handcuffs at the table. But she's very, very, you'll see. We'll just let this play.
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been.
right, it's in your history.
Okay. Thank you for the information.
Any follow-ups, Dave?
No, Your Honor.
Thank you, sir. Anything else, Dave?
Not from the state.
Okay. See Deputy Barnett here. Could you come up, sir?
Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Chad Barnett.
And not your date of birth, sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T. ETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's box secured to the leg. It has 50,000 volts and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants and it gives the ability to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There's a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the
Sudden
device.
movement.
It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the stun belt? Other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
3 would be failing to follow the directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun
Cuff.
cuff.
And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you have to resign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes,
and remove?
yes.
Thank you.
Any follow-up?
Nothing to say.
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
Thank you, sir. State any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you could move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs.
Why did Court TV come up all close on her shackles? They were wrong for that. They got all close. See, that's the kind of thing that does get cameras in trouble in the courtroom, but nonetheless, she is shackled. She has a waist belt on, and with the waist belt, she has these pink handcuffs on. So this is the rub right now.
If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that, again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial, yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the sheriff's office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she's an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why.
Oh my God. I just had a thought. They haven't even started picking a jury yet. Oh my God. This is going to be crazy. Someone asked, and I want to address this question right here. Maybe she doesn't hear well, which would explain her not hearing her boyfriend calling out the suitcase. Yeah, that's not accurate. Go to my playlist and watch the very first video I ever did on Sarah Boone. She has cell phone video of her boyfriend in the suitcase. Sarah, let me out, Sarah. And she was pissy drunk. This is now, what did she say? She was saying all kinds of crazy stuff. It was awful. It was absolutely one of the most awful things you've ever seen. All you have to do is type in Sarah Boone's suitcase and you will see the cell phone video of the situation and then jump down the rabbit hole to the body worn camera video that when they show up to the scene, the morning after she discovers that George has passed and he's still in the suitcase and she's trying to think of a good story. of how to really explain this, and the officer that showed up was not having it. So yeah, I don't think that's it. That was very sweet. But no, I think she hears just fine. She just doesn't like anything that is not consistent with what she wants. She's very much entitled. So yeah.
I would want to set for today to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed to be able to progressive.
I wish someone would just say you don't have to be you don't have to not have an attorney. Florida is not paying for it anymore. I just wish that they would say it one more time for her so that she can get it through her skull. You can have a lawyer all you want, sis. Florida is no longer paying. That's it. You can have a lawyer. You can have a lawyer. Florida's not paying for it anymore. They're done. So hire a lawyer and get the lawyer over here. Other than that, then you're on your own. That's it. That's all.
And to actively participate properly and the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings.
When she said futuristically, I was like, what?
Readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns which she's
Got it. All right. Thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 17.
Yeah, I'm looking for the comment. I don't see any comments deleted. I had to go over to my YouTube monitor because when I do this, when I'm clicking on comments, I'm on a different screen. I'm on the StreamYard app, and I was trying to see, was there a comment deleted? Because I can see like if a moderator deletes something, if I catch it in time. But I don't see anything. Oh, here you go, right here. I don't see anything. What was the comment that was deleted? Can you just drop it again? Sometimes the bot does get them. So I mean, we don't have a lot of that, but it happens. I didn't see any comments being deleted, but if it, sometimes the bot gets it. I don't see where. Yeah, normally we can see, like, if you have moderator capabilities, you can see where a moderator took a comment out for some reason, and I don't see it, hun. YouTube soft blocks my comments all the time. Yeah, I mean, sometimes some stuff just doesn't come through, but don't take it personal. I'm gonna be real honest with you. Just drop it again because we're there. This thing is always glitching. Just keep in mind, it's almost hard to conceive how many users are on here at the same time. There's a lot of users in YouTube. I mean, what I'm saying? Like, millions of people using this app all at the same time, somewhere it's going to fail, and sometimes messages just don't come through. Just pop it through one more time. But yeah, no, it wasn't deleted.
78 by the Florida Supreme Court in
I don't think.
2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first degree murder.
She did.
And there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder was representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of the stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, and especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward.
Okay, so they're getting ready to get to the part where they rule, and they do end up ruling in her favor. Did I see the video where she had her son in the suitcase? I did not see it. I heard about it, and I know that CPS was called, and it was a problem. Maybe she's got some sort of sycophant, she's some sort of sycophant, whatever the word is, regarding something about some damn suitcases. I'm not really sure. That's strange to me why she would do something odd like that, but this whole case is odd. But this thing with her and George, unfortunately it was going to end this way. When you come into the chat now and AI is reading the chat, I mean, AI, this is YouTube's platform. YouTube can do whatever they want. You know what I mean? This live could, like they shut down lives. YouTube as a platform does what they want to do. But yeah, sometimes that just happens. Just, just take it on the side of a glitch. I mean, sometimes things do happen in comments, but we're not heavy comment deleters over here. That doesn't happen very much. So, I mean, that doesn't happen very much that I've seen. So, it just err on the side of a glitch. In any case, let's hear the ruling. We have like 20 more minutes. You saw
No,
what?
We
You saw
defer
it?
to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's
I
given a
don't,
fair
you know what I
trial.
mean? Like, I don't know. I'm just throwing that out. I don't know if she
Remedy
has
that is
that or
fair,
not. It's weird.
Presentation for the jury.
She
Okay,
posted
perfect.
she
Thank you.
posted
All right,
on
so
her
ma'am, the
Facebook.
court's gonna grant your motion.
She posted on her Facebook, and this is why CPS was called, as they should have. She's weird. Plus she has, also when you hate your baby daddy, I think when you hate your baby daddy or you hate your baby mom, I think there can be some danger there. We've seen it far too much. I mean, who's the guy who just recently the whole thing with the little boys and the father? He's got to have some sort of hate. He has some hate towards the mother. Look, something is there, right? Um, I don't know. I don't know if her boy was in danger, but ma'am had a very horrible drinking habit, Chad Dorman. There's so many situations that we could talk about where there's hate for the other parent or the parent, and it's a step parent, and it's very sad. It needed to be called out to CPS. It's unfortunate that unfortunately George Torres did not end the relationship soon enough or get away. You know what I mean? Because there was some dual, I don't know if who was the more aggressive with the two, but there was domestic violence on both sides. This couple just needed to have broken up a long time ago. It's unfortunate, but she's where she's at, and it's a sad story.
And then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay, you may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with the Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated.
This is my thing. Did you just hear his answer? You'll sit at the table, you'll have the cuff on your leg, and you'll be hands-free. But she has to ask another question, which is basically like, look at the corporal. Like, didn't he just answer your question, ma'am? He just answered your question. Sometimes, you know how like in sales or just in general, you got to listen. Sometimes we're so busy trying to formulate our next question or our next argument about anything, or if you do presentations at work and things like that, sometimes you have to listen to your audience, because she just got the answer to her question, but here she goes, still belaboring.
Counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Handcuffs off, stun cuff on her leg.
The other item I
Ooh,
have.
look at them showing her
Yes,
leg.
The sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality, because it's just you and me and the state, and no jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off.
In
when
advance.
she gets up here.
Yeah, I agree. I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And as identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to?
It is under your clothing, as Sergeant Barnett identified. I have a representative from the public defender's office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes,
Okay?
thank you.
All right. Does that clarify for you?
Oh my
Steve?
God.
Yes, I just saw them and I thought that, I saw the confusion based on my experience and how it's done.
Okay.
Who cleared it up?
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
They should put some tape on the floor. They should just like, especially like with COVID, how they had the 6-foot rule, just make a 6-foot rule box so that if she decides to get up and talk and stretch out her legs or whatever, just put some tape on the floor. Just tape the floor down and do not cross this line. Just stay. That's it.
Are you okay with addressing that later, counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you. Okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of a trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank
Okay,
you.
that's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State anything to clarify.
No, Your Honor.
Okay. All right, the last issue that
I just think they want to, she's getting a lot of privilege, but I think that, at the end of the day, I don't know where her case is. I don't know what she's going to argue that, the video is really the most damning piece of evidence. And anyone that they bring up to talk about their relationship, the family hated her. Okay. And she's afraid of the Torres family. Okay. I don't know whatever witnesses they decide to bring up, if they talk about the son situation, him being in the suitcase, how she tried to bring in her ex-husband and kind of get him in the mix, and he was just like, yeah, no, call the police. That whole thing with the ex-husband rather, I don't know what witnesses they're going to be calling that she really needs to. I mean, I'm sure she's going to cross-examine the witnesses, but her set of witnesses, she's cooked. Then when they play the video, she's done. When they play the video of George begging for his life, they're done. It's going to be a wrap for her, sis. This is, and you know what I mean? Florida, they don't mind putting somebody away. Like at the end of the day, ma'am, you are really, like, everybody knows it's just a matter of when, not if. So I don't think that there's any extenuating circumstances that she can provide for anyone to give any kind of stretch of the imagination that she's going to be walking about that jail. I think the judge is working really hard to make sure she gets the best process as possible, because this was this was a play that they had to make to get this show on the road, because she is a nuisance with these damn lawyers. And now that she doesn't have anyone to blame but herself, he's going to be as patient as possible to guide her through this process, but they are trying to stay on track with her. They're not playing with her at all. Yeah, she could actually talk herself into a life sentence, because if people really feel like what she did to George, like George basically had to sit there and beg for his last breath. And she was pissy ass drunk. You gotta, if you're here and you have not seen that, if you can stomach it, it's not like gory or anything. It's just quite disturbing and it's very sad. But I think, she says that she went upstairs and fell asleep, left him in the suitcase, came back downstairs, he was dead. Someone said in the chats one day that they believe that she probably just laid there and passed out on the couch. Like she played cat and mouse with him all night. In the suitcase, she might have just laid there and watched and listened to him die. She may have just flat out just passed out and he passed away. Any of the scenarios I just mentioned, it's all possible. It's all very possible. She's the only one that knows, and her dumbass videotaped all of it, and it was all up in her phone, and the police got it. And that is the most damning evidence against her, which is probably going to send her away for a very long time.
I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report, you were just speaking about regarding them providing me with a laptop each day. What is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information of the protocol, ma'am. It's just simply what is checked out and returned.
See, when she asks questions like that, sometimes you might think for a second like Sarah Boone's a little bit smart, but then she asks a question like that and it's like, sis, these are sheriff's department. This isn't the IT department. They're not dissecting your computer every night to see what you went through. You are going through your discovery. That's what they've loaded to the computer and that's what you have access to. Do they need to validate that you're looking at the discovery? I don't think that the judge cares. If you decide to never look at the discovery and not prepare yourself a defense, that's going to be your business. And then maybe they'll look at that at the time of an appeal and say they provided you a computer and they went through the computer and noticed that you never even bothered to go through your discovery. That's not what they want. They want a log to verify and validate that every day you get that computer, so your complaining ass doesn't come back and say that you didn't have access to the computer. The judge wants to know and wants verification by close of business that you have gotten access to what he has ordered for you to have, so he doesn't have to hear from your mouth that you don't have what you need. That's all he's saying. Like, it's like, sis, are you dumb?
under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. in courtroom 12A, Orange County Courthouse, and then the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I've pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
Okay, so I need to read through this last bit of correspondence she sent because he said something about a media issue. Okay, so maybe he means the media issue as it pertains to the computer, and her not being able to access some things. Earlier in the hearing, she mentioned that she could not access some files. So maybe he meant media as in the actual files, not like media as in the broadcasters and bloggers and all of the things. Thank you so much, Name Changed 412. I appreciate you so much for gifting some friends in the chat. How generous of you, and I appreciate that so much. Kenna, Black Rose, Marilyn, Lady T, and hard hitting one, you got gifted by our friend Name Changed 412, and I appreciate you so much for doing that. Thank you very much. I appreciate it. Let's finish this up. We just have like literally 7 minutes.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank
And
you.
that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane?
Oh, no, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, you could give your letter to the deputy. We will file that in the court file.
Thanks.
Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain Di Giovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd.
She thinks that a public hearing for a trial for the murder, where the state is prosecuting you for the murder of a human being that you had no rights to manipulate their death, that is your personal private business, like you're at some sort of funeral home. You think you're at a funeral home? Sis, you're in the courthouse. You're at the felony courthouse on second-degree murder trial, sis. That's not your personal private business. That's the business of the state of Florida and the family of George Torres, okay? What is you talking about? It's like, ma'am, really? Did she just say that, guys? I'm trying to find the motion now. It must be in one of the three that she filed the other day. I see this one. So she filed this one. This was the immediate address change, that whole drama with her address, the legal mail versus the this is that might be formal address change. Did I already look at that one? Motion for defendant's immediate address correction in response to proper notice and preparation. The defendant's okay. That's not it. Then she had this one. She's filed like 4 motions in the past couple of days. The motion for defendant's reasonable freedom for movement and allowing her to be unshackled, unhandcuffed, and function equally and comfortably while utilizing the courtroom. She got that one. Um, the defendant is simply requesting equal, comfortable. Okay. Okay, that's that. Where is this thing about the media? That's what I want to hear. Is that in this? Motion for lawfully receive, review, utilize original copies of discovery submitted to the court by former attorney. Comes now Sarah Boone, pro se, indigent, da, 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 lawful support and valid reasons for this request made by defendant, discovery, definition, filed and posted, boxes A and B. I want to see where she's talking about that she doesn't want the media. If people weren't going to show up, they're going to be there now. It's not reasonable like the burden of something. The government is obligated under Brady. So she's asking for her discovery. Write notes, remarks, informal defendant's discovery unavailable, and others should be available without interruption and unrestricted full access equals. She's going to have her discovery, but she doesn't want her discovery evidentiary meeting televised. Do they even do that? I don't know if they even do that. Typically, do you guys know? I'm going to see if I can find it. Anyway, let's go back to her. Let's go back to the last couple minutes of this because there's only like 2 minutes left, but this is when it got juicy.
Right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay.
I got to find that. When I find that motion, I'll come back and we'll talk about it. I'm just clicking on the last 4 motions. I don't see that in there, but it might be in that she gave them something. She gave them a bigger document. Certificate of mail. Did I not click on this one? 1, 2, 3, 4, 5. Didn't I click on that one too? Yeah, that's order. Notice. Certificate, correspondence from judge. Received from judge. It might be in one of those 2 bigger documents. I'm not sure. She must have mentioned it somewhere, but I'll find it. Because I want to see what she said exactly about that matter. Have any of you guys heard of this? I'm sure she's trying to flash. I don't know what I'm assuming, look, she's nuts. She's nuts. It didn't work for DJT, and it's not going to work for her. $5 says she gets her way. That she doesn't have the camera. Maybe they might not have the camera. Maybe they can do something where they're not going to have the camera. First of all, like when they do this type of a meeting, I wonder if they don't televise those anyway, but I don't know. I don't know if that's something because look, I don't know that I've seen hearings where they're going through evidence prior to. Maybe they do. I'm not sure. This is all new to me because I'm not sure if that's something that we typically get to see. Sometimes we're not always seeing pretrial stuff. You know what I mean? This is interesting where a lot of times we're seeing cases and it's picking up on day 1 opening statements, right? We don't always get to see pretrial stuff. I mean, or does everyone always watch pretrial? You know what I mean? I don't think pretrial is always covered. And I don't know that even if it's happening, if I'm watching it, right? We're just getting privy to a lot of this because it's quite interesting because she's such a character, right? But we're going to get into it. There's another hearing on the 14th, which is what? The 14th is going to be Wednesday, guys. Court at 1:45 on Wednesday with Ms. Boone. Okay. Until then, I'm going to see if I can get my hands on, because I'm looking at the notes from today, where it says the court granted defendant's motion to lawfully receive, review, utilize the original hard copies in discovery. The state provided Billy Lane, representative from Prison Break Investigations, a thumbnail which with the digital evidence in open court. Billy Lane to go to Orange County Jail Tuesday, 8/9/24, to meet with Major Mohammed and provide him the 2 boxes of discovery along with the thumbnail drive to be provided to the defendant to provide in writing any objections she has to the digital discovery by 8/23. The court heard testimony on the defendant's motion for reasonable freedom of movement. After hearing the testimony and arguments, the court granted. The court ruled that the defendant to be hands-free but legs shackled and seated at counsel table for any motions moving forward. Defendant to be hands-free with stun cuff and seated at counsel's table for trial. Defendant must sign waiver for the stun cuff. The defendant provided a letter to the court identifying her concerns. The court will review and address on 8/14 all previous dates set to remain. Let's see. Hold on. What else did they have? They give a nice little synopsis on the docket. I love how they do things. What else? The court went through the mailings of documents with defendant. The defendant advised the court that she received everything from the court mentioned. However, she still needs to finish going through her mail. The court assured her that nothing is being withheld from her. Court witnesses sworn and testified. Billy Lane, Sergeant Chad Barnett, state's notice of provision of witness list filed in open court to be placed under seal. Okay, the witness list. Okay. We're not going to get to see that, but that's fine. Anyway, we'll find out. Anyway, okay. And I'm sure they'll be providing the minutes. This is today, and the minutes will be posted. They'll do like a formal minutes and have that posted. So anyway, 8/14, that status hearing she's not happy about. She does not want the media there when she goes through her evidence. And it might be too bad, so sad. So we'll see how that flushes out. I don't think I've ever seen one. All this pretrial stuff, it's pretty cool, right? I mean, we're seeing pretrial with Nesto because he showed up. That was a pretrial, right? When he goes to court in October, that's going to be the last. Well, I guess we're going to be getting into pretrial. See how that works. They're going to have to pick a jury soon, all of the things, but it's moving right along. I want to thank Pen Pal 50 and Name Changed 412. Thank you guys so much for supporting the channel and providing some memberships, and sis, I think, renewing her membership. So thank you so much for the support. It goes a very long way and it's very much appreciated. Thank you so much. Other than that, I think I'm going to let you guys go. I'm going to be over. I need to get my dinner started before my husband gets home. So I'm going to see you guys a little bit later on OSIP. We're going to maybe open up the phone lines and talk a little bit about the spin the block situation of the new daddy, new husband, driving around with no insurance over at the casino with X pills. Who is that? That's Mr. Cornell Hayes, with his new wife Ashanti, who maybe was probably home with the baby. And Sir was out at the casino and says that he feels like he was racially profiled. But Sir, what a way to get racially profiled and have allegedly some X on you. Okay, that's bad news, right? That was a bad day for him, right? Anyway, guys, I'm gonna let you guys go. Please hit the like button for me. Share this video. Share. If you're new here, you're in the bushes, you haven't subscribed yet, subscribe to this channel. Make sure to hit your notifications and hit that thumbs up for me. I really appreciate it. Daddy didn't want to hear the baby. Girl, sir is let me get it right, 49. I say, almost 50, 50. I mean, he's damn near 50 years old. At the end of the day, it's like, sit down, Nelly, have a seat. Sir, you opted in to have a baby at 50. You are certainly on some been there, done that. You've got two of your own. You've raised your niece and nephew, I think. Sir, have a seat. But you opted in for a brand new, fresh one. You and Ashanti's going through it. 44 with a brand new baby. My God. No car insurance X at the casino. They just had the baby. What are you doing at the casino? Why are you not home, tending to your wife and your baby? Okay. We'll talk about it over there. I'm gonna drop the call in so you guys can tell me what you think. Anyway, guys, I'm gonna let y'all go. Have a wonderful evening, y'all. I love you. Take care. Do I have I was about to say, hold on a second. Let me go back over here. Okay. Guys, have a good evening. Bye.